Hello YouTube, welcome back to Know Your Law channel. I do apologise I haven't uploaded in a while. I've been busy with a few other things, but I'm back today, and on today's episode we are covering the topic of robbery. We're going to look briefly at the definition of robbery and also the elements that constitute the offence of robbery. So let's get into those now. So for the definition of robbery, we get this from section 8 subsection 1 of the Theft Act, and it basically says a person is guilty of robbery if they steal and use force, or the belief that force will be used, immediately before or at the time and in order to secure the theft of property. So with robbery and all other crimes we've looked at, we have two sections. That's the act and the mental element. The act can be split into four subsections. Those are stealing, immediately before or at the time, in order to do so, and the belief that the victim will be subject to force. The mental element is actually the same as it is for theft, so that's dishonesty and intention to permanently deprive the victim of their property. If you want to know a little bit more about those in a bit more depth, just check the link in the comment section below to the previous episode, which was on theft, to cover it in a bit more detail. So we're going to look at the act, and let's look at the first part of the act. So for the first part of the act, we have stealing, and this actually has the same meaning in robbery as it does under theft. So if you want to know a bit more about that, again, check the link in the description below. So for the second part of the act, we have immediately before or at the time. We have a few cases here to help us understand this concept. The first case is R.V. Hale from 1978. In this case, it was decided that the appropriation, so that assumption of the owner's rights, is actually a continuing act, and it can exist after, not just before or at the time, it can go after. Now, if you find that a bit confusing, the reason the judges went in this direction is they're more looking at the force used to assist in the theft of property, and that can exist after as well. So that's why they went with that sort of reasoning. The second case is R.V. Lockley from 1995. This just confirms Hale as good law. Also said in this case that force used to assist in escaping is also force used to assist in theft, and that makes sense as well, because if a robber is trying to run away, someone gets in their way and they hit them, that's also force used to help in theft of that property. So for the third part of the act, we have and in order to do so, and with this concept we look at whether or not the force used was done in order to help assist with theft of property. We have a few cases here to help us demonstrate this point. The first case is R against Dawson and James from 1976. Here it was held that force is not a defined concept, and it would depend on a case-by-case basis if the actions amount to force used, and that's a question for the jury to look at. Also, it's held here that force need not be substantial or violent, and this is actually a concept that we see developed further in the next case of Corcoran against Anderton from 1980, and in this case it was held that merely touching the property is sufficient for force used in order to steal. We also have, lastly here, the case of R against Clouden from 1987, which says that force used solely on the property and not against the person is sufficient enough to amount to force use against the person. Now, if that's a bit confusing, we kind of just look at this general concept in robbery of force use in order to steal, in order to assist in the theft of property, of which that is one. So for the last part of the act, we look at whether or not the defendant sought to put the victim in a position where the victim would fear the use of force. We have two cases here to help us look at this point. The first of these cases is Smith and Desmond from 1965, and here it was said that force doesn't need to be used against the owner of the property, just that the owner fears the use that force would be used against them. Now this case is from 1965. The Theft Act came out in 1968, so what the Theft Act basically did is just put that case into the statute. The last case we have here is R against DPP from 2007. This is a bit more of an interesting case because here the victim wasn't actually afraid of the force being used against them or threatened against them, but this still constituted robbery because it's what the defendant intends to do. If the defendant intends to use force or intends to put the victim in a position where they fear the use of force, that's sufficient for robbery. So that concludes the episode. Hopefully you've learned a bit more about the law of robbery in the UK. If you have any questions, please leave them in the comments down below. I will get to them. I will have a look at them, and I can't wait to hear what you guys have to say. So thanks for watching and have a good day.